Well, thank you for those that are attending the January 14th, 2020 zoning bylaw update project presentation. My name is Steve Sadwick. I'm the Assistant Town Manager here in Tewksbury, and Anna McGinty is to my left. Anna is the Town Planner. So this evening, what we're going to do is the contents are laid out here. Talk a little bit about the committee and the consultants, and then what the committee has been up to, the scope of the committee that was laid out by the Board of Selectmen, new features that are being proposed in this draft zoning bylaw, changes in how the bylaw is organized, additions to the bylaw, removals, significant modifications, and then we'll talk about zoning map changes. So the committee are these members here. It includes Robert Fowler, who is a planning board member, Ed Johnson, who is the building commissioner, and by virtue of building commissioner, he is the zoning enforcement officer. Richard Cuco, who has been a land use consultant in town for a number of years, working on the private sector, but what he brings to the table is also his experience in other communities, which was one of the reasons why he was appointed to the committee. Erin Wortman is a resident here, and those initials after her name are for the American Institute of Certified Planners. Erin is the Community Development Director, planner for the town of Stoneham. She's a resident here in Tewksbury. And then Mark Kratman is the Board of Selectmen representative to the committee. On the consultant side, we have Judy Barrett, who started the project with RKG Associates and then ended up with her own firm, Barrett Planning Group. And Judy has done a number of zoning bylaws across the Commonwealth and was our consultant on our 2003 master plan, and then came in at the end of our 2016 master plan to help us wrap that up. Robert Mitchell is another land use planner on the consulting team, and Mr. Mitchell has he served as planning director of Burlington, Vermont, Amherst, was an adjunct planning professor at UMass Amherst, and then worked for state government for a number of years before he went into private consulting. Robert Ritchie is the former town council for the town of Amherst, and then worked in the Attorney General's office in the municipal law unit. So his office actually saw all zoning bylaws that were approved by town meetings. It was his office's responsibility to review them and then approve them. So he brings a wealth of knowledge to the table. And then David Gamble is an architect who assisted us with some design standards later in the project. So staff, again, there's myself and Anna, and then Dawn Cathcart, who was the recording secretary during the whole process. She works in the building department, permit technician, and has been the recording secretary for the planning board for probably 14, 15 years. So Dawn had a lot of institutional knowledge on how we address our zoning in Tewksbury. So since the formation back in 2016, the committee has met 34 times, and that's in addition to 4 joint meetings that were held with the planning board. There were 2 public input sessions that occurred early on back in 2017. There was a public presentation with the planning board regarding the design standards. Again, that was what David Gamble had worked on for the committee. There was a presentation to the Board of Selectmen and Planning Board. This was a joint meeting that was held this summer back in June. And then there were 2 public presentations like this evening that were conducted in December. And we have 3 presentations scheduled for January, this being the first of the 3. So here is the scope that was laid out by the Board of Selectmen when they appointed the committee. One was to select the consulting review team to help update the zoning bylaw. Where the committee was to look at the existing language and make sure it was in compliance with the most recent edition of Bylaw Chapter 48, which is the zoning act, the state zoning act. So then the committee worked with the consultant and was supposed to work with the consultant, a number of boards and committees to develop the bylaw that's consistent with the town's master plan. And that was kind of accomplished through some of the zoning districts that resulted out of this process. Prompt and predictable permitting while protecting a butter's rights was a goal to be achieved through a new zoning bylaw. Again, this was one of the charges from the selectmen's initial mission statement to the committee. Project will include looking at various zoning districts and in determining whether the community's objectives are being met. And there were some adjustments that were made throughout the process. And then draft zoning bylaw will be prepared for town meeting as an end result of this project. The warrant for town meeting closes January 31st, and it looks like the committee will be hitting the deadline to get submission for the town meeting this coming May. So new features of the zoning bylaw. There was a zoning diagnostic that was conducted by the consultants and delivered to the committee to determine the status of the bylaw relative to consistency, both internally and with state and federal statutes. Now, the consistency internally was, we did find that there were a number of places in the existing bylaw where things were inconsistent. And this was just due to the nature of the bylaw itself evolving over time. The bylaw we're operating off of currently was a 2002 recodification of the zoning bylaw. So it's pretty much run about 18 years now. And over time, as it's been amended, there was upwards of, I think, 120 plus amendments that have occurred since 2002. And over the course of time, it gets a little bit clunky and things do tend to become inconsistent. The second feature here is to recodify the bylaw for ease of use and for future updates. We're proposing to change the numbering system to make it easier for amendments to be made in the future. And then as far as ease of use is concerned, the existing bylaw has things that are somewhat fragmented in the bylaw. When we talk about development design standards, those things relative to parking, landscaping, buffers, you can find those in 3 different sections of the existing bylaw. So it makes it a little bit challenging for people to understand and interpret our current bylaw. This proposed bylaw pulls everything together into one section so that it's there for you very readily and easy to see. The new bylaw picks up a number of the most recent town meeting votes and incorporates it into this draft bylaw. Amending of the zoning map to reflect the 2003 and 2016 master plan. In both the 2003 and 2016 master plan, there was discussions about Route 38 having one zoning district that ran from the Lowell line to the Wilmington town line, and that's the commercial district. The 2003 master plan talked about breaking the zoning districts along Route 38 into different districts, which were more reflective of the character of certain sections of Route 38. In 2009, the planning board started bringing to town meeting overlay districts, which were an attempt to change or add to the existing zoning bylaw characteristics that would meet those areas of town. So we had a town center overlay district, we had a village residential district, we had a village mixed use district. These are all overlay districts. Community village overlay district, South Village overlay district, all of those sat on top of the underlying commercial district. So what this bylaw has done is really kind of remove the overlays and drop them down as the base zoning for Route 38, so that you're really achieving those character districts that were first referenced in 2003, which gets to the next bullet, which is reduce the number of overlay districts. The remaining overlay districts, the committee felt were necessary to leave alone as overlay districts. There's a floodplain overlay district, a groundwater protection overlay district, medical marijuana overlay district, and an interstate overlay district. And that interstate overlay district, I think we put that into place around 2004, and that was to allow for certain uses close to the interstate interchanges. So you'll find Woburn Street has the interstate overlay district. Route 38 has the interstate overlay district, and then the Route 40 or interchange 42, the Dascom Road East Street has an overlay district. So those remained in place. And then the last bullet is strengthening design guidelines for town center. There are now design guidelines that are in this zoning bylaw to help shape town center development in a standardized fashion to demonstrate what the expectations are for the town center. So new features of the zoning bylaw. One of the things that we realized with the overlay districts was that there was never a cap on the density. So the density are defined as the number of units per acre. So in this new bylaw, all multifamily developments are now capped at 7 units per acre except in the town center. And for planning purposes, town center is where you want things to be a little bit more dense. So there is no cap on multifamily in the town center. Those 7 units per acre is really the standard that's in the existing bylaw for the multifamily district. Now, I was talking earlier before we started, the town has a number of different types of multifamily districts in town, and most of them adhere to the 7 units per acre. It was the overlays that we didn't have caps on the density. So that did create more density than I think was expected, and was kind of outside of the bounds of what people had come to expect for multifamily developments. Another new feature is requiring affordable units in multifamily developments. The town has what's called an inclusionary zoning section of the bylaw. And what that does is that it says that if you're getting a special permit for housing, you need to include affordable housing in those developments. Or you can ask for a waiver of that by providing a fee in lieu of those affordable units. What's happened over time since we've had that bylaw in place is that there have been a number of developments that have been approved with the fee in lieu of the affordable units, and they have paid the town that fee so that the town can develop affordable housing. And what we're doing with the new bylaw here is requiring that the affordable units be built in multifamily projects. So any type of apartment building, any type of townhouse project will have an affordable component in it going forward if this bylaw is approved. The next bullet is reducing confusion to owners, abutters, and others by replacing those significant number of overlays with the base zoning districts, something that I think I've mentioned at least 2 or 3 times now. Recodifying the bylaw for ease of use and future updates. Again, that's by reorganizing it and changing the numbering system, amending the zoning map, as I had stated earlier, adding criteria for issuing special permits. So the way that zoning is set up, there are uses that are allowed by right, so that you don't have to come to a board. You can proceed to get a building permit for certain types of uses. There are uses that are prohibited that we call out and say, we don't want these types of uses in our town. And then there are those that are discretionary, that need special attention. And in fact, in other states, they call them conditional permits. So it's really special conditions that would allow this type of development to occur. Here in Massachusetts, we call them straight out special permits, and that's where you would have to go to a board, planning board, zoning board of appeals, and make your case. What we've done with this new bylaw is to add criteria for the issuance of those special permits so that the planning board has something to operate off of that's in the bylaw. The developers know what that criteria is, as will the abutters. The sign section of the bylaw was rewritten to bring it into compliance with recent court cases. When you start talking about signs, it's one of those things that is protected under the First Amendment of the U.S. Constitution. And there's been a number of Supreme Court cases over the years that have kind of dictated how communities can regulate signs. And we really needed to have a close look at how we regulated signs based on content. That was the most recent Supreme Court decision. That was probably about 3 or 4 years ago. And this is where Bob Ritchie, who was the former Assistant Attorney General, was very helpful in helping us rewrite that section of the bylaw. And I think I had referenced earlier that all site development standards now show up in just one section of the zoning bylaw. So changes in how the bylaw is organized, I'm not going to read through all of these, but you can see that we put section 2 definitions. We wanted to make sure that definitions were right up front so that everybody saw the definitions before you dove into the bylaw itself. Our current bylaw has the definitions at the end of the bylaw. You know, the committee just felt that it made more sense to have it up front. The administration was moved to the front of the bylaw also. And then the other things, you know, just kind of follow suit. I think section 5 is where there's a lot of information packed into that section with descriptions of the districts, design, dimensional and density requirements, use regulations, and then we talk about the 4 remaining overlay districts. And then it turns out that section 8 is all other regulations. So those are things like non-conforming uses and structures, multifamily dwellings, that affordable housing requirement that I referenced earlier, open space residential developments, which is a technique used with subdivisions, and then wireless communications and adult use marijuana establishments. So we've added new definitions to the bylaw. We've also added in site plan review, which is something new to the town of Tewksbury. We have currently site plan special permits, but what site plan review will allow the town to do is to regulate by right uses, but in a non-discretionary fashion. We have requests for reasonable accommodations. This is mainly to address Fair Housing Act issues as well as Americans with Disability Act issues. We've included district purposes, which is something new, which basically tells the reader what we're trying to achieve in these different districts that we have. like I had said earlier, we have town center district development standards, and then the adult use marijuana establishment that was added, and this came out of the last town meeting vote that there were some uses that, such as cultivation of recreational marijuana, testing, and manufacturing of marijuana products that was banned by a previous town meeting but had a sunset in it. And what happened was at the last town meeting, they wanted to let the sunset expire, and when it did that, it opened up that we needed to address those three things. So now, in this bylaw, it picks up on how those types of establishments will be regulated and permitted through the planning board. Things that were removed from the bylaw were single-family structures in commercial and industrial districts. In a discussion with the committee and with the planning board, it was decided that if we're calling areas commercial or industrial, that's what we want to encourage, and we don't want single-family development in those districts. So that was removed from the bylaw, the draft bylaw. Transition district regulations were removed because those are things that are typically addressed during a special permit process, which most of the uses in the transition district would be faced with. Accessory uses in the office research district was removed, and again, that was to loosen up some of the restrictions on those uses that were identified as accessory uses. The wireless overlay district was removed, but there still remains a wireless overlay regulation section. So people will be coming into the planning board for special permits for wireless towers, but again, federal preemption allows them to go anywhere. And what we were trying to do with our overlay district was to direct them where to go. And the consultants found that to be in conflict with the federal statutes. The MFD 55 district and community development district, both of those are these multifamily districts that we have that we've kind of consolidated into one type of multifamily district. Those are the overlay districts that were being removed in their entirety. The Highway Corridor Overlay District dates back to 2004, and that was when there was a mall proposed off of Route 93 down by South Street. And the likelihood of a mall being built in today's retail environment is negligible, if alive at all. And by removing that overlay district, it just is residential, which is what exists today. So the corridor overlay, that corridor overlay district was really, you couldn't use it unless you were able to get an interchange off of Route 93. And the likelihood of that happening is very minimal. There was a long process that we were involved with for over 6 years with state and federal agencies trying to get permits to open up 93 there, and it didn't work, and then the real estate market collapsed, and the mall company that was pushing this went bankrupt, and so that's the story behind that overlay district. The Community Village Overlay District disappears in this draft bylaw. In some sections, it gets incorporated to a mixed-use business district, and in other areas, I think it's picked up by a multifamily district. So development impact statements were removed from the bylaw. This is something that was never used. It was put in back in 2002 along the lines of the state's Environmental Protection Act, and that act, the MEPA Act, is for significant size projects. So the committee decided that, being that it was never used, that there were other ways of addressing the issues that were in this section of the bylaw. And then section 9500 was use special permits. Again, the inconsistencies that grew out over time with the bylaw, we had a use table which told you what you needed to have for use special permits. We had a site plan special permit, which was based on the size of a project. And then we had section 9500 here, which talked about different types of triggers. So we decided that we would strictly go with a use table, and that anything else, such as those types of triggers that showed up in this, would really be rolled into our site plan review process. So for significant modifications, again, these overlay districts along Route 38 have all become underlying districts now in some fashion. The current commercial district on Route 38, there's a section in the bylaw that says that it has to be 291 feet along each side of Main Street. And as has been explained to me, because this was in the bylaw before I started with the town 18 and a half years ago, this was so that you could get an acre lot on Route 38. It had to be 150 feet frontage and then 291 feet deep, which created a significant number of problems because you ended up split zoning certain lots, and then you had to make up exceptions for that. So what we've done with the new zoning map is to take all zoning districts to the parcel boundaries. Billboards, the town does allow for billboards. Right now, is the bylaw, the current bylaw has 100 or 1,000 feet from any residential or multifamily district or use, and that's being changed in this bylaw to 500 feet from any residential use. Just for reference, 500 feet is approximately the width of an interstate right-of-way. So as you're driving along 495, it would be from one side of 495 to the other side of 495. The medical marijuana overlay district, there were two things in that section of the bylaw that were removed. One was a cap of 5,000 square feet, and that we could only have one non-exempt dispensary located in town. And one of the things, and I just realized I'm looking at this, we also, the committee also allowed for dispensaries to be located in mixed-use buildings. When I say mixed use, the way that the current bylaw reads is that it had to be in a standalone building. So a dispensary now for medical marijuana in the proposed bylaw could be in a building that has other businesses located in it. Large-scale ground-mounted solar facilities, the minimum lot size was reduced from 20 acres to 5 acres, and that's for solar farms. We had our regional planning agency has a specialist when it comes to energy efficiency. He's helped us with our Green Communities program, and he surveyed a number of communities and providers, and 5 acres appeared to be, on average, the size of solar farms. And then, like I said earlier, the affordable housing requirement of 15% is now is being required in all multifamily developments. The zoning map changes, again, breaking up the commercial district into the smaller zones, brought the zoning district boundaries to the lot lines, change the Great Swamp zoning from heavy industrial to park district. And then what we did was, and this was after a very, very lengthy conversation, small lot zoning dimensional requirements are placed in the text of the bylaw. And then there's going to be a study commenced by the planning board and staff upon approval of the proposed bylaw. So in talking through this, we looked at, the committee kind of went outside of its scope and started looking at small lot zoning and identified 11 sections of town and said, well, let's study these a little bit more. So we started looking at what the average lot size were in these different areas of town. And as we were looking at these, we also started looking at other communities and how they had residential lots that were less than an acre. In Tewksbury, it's 1 acre zoning throughout town, whether it's in North Tewksbury, South Tewksbury, West Tewksbury, it's all 1 acre zoning, which presents problems making a significant number of neighborhoods non-conforming because your lots were created prior to that 1 acre zoning that went into effect back in 1955 or 1956. So they started looking at this, and there was a little bit of a pushback on it, and finally the committee and the planning board said, you know what, we know ideally what we would like to see for 1/4 acre zoning and 1/2 acre zoning. So they put those dimensions into the zoning bylaw, but we don't show anything on the map, because if this zoning bylaw passes, the planning board and staff will be out in neighborhoods talking about changing the zoning to smaller lots. We just realized that going through, there's enough changes buried in this draft zoning bylaw, and to take on rezoning residential neighborhoods was, and to do it right, was a monumental task that needed to be done aside from this. So if this bylaw passes, really phase 2 will be talking to neighborhoods and seeing if neighborhoods want to have zoning change to reflect what's on the ground. And then moving forward, tonight's public session, there's a public session tomorrow at 10 a.m. at the Senior Center. We'll be back here on Thursday, the 23rd. The warrant article will be submitted by the 31st. In April, the planning board is required to hold public hearings for zoning articles, and that will occur at the beginning of April and could lend itself to the second planning board meeting in April. And then May 4th is the annual town meeting. That's the end of the presentation. Oh, for more information, the Zoning Bylaw Committee's webpage is listed here. We encourage people to sign up on the town's website to receive e-alerts of the committee's activities and postings. And then we set up a separate email address at zoning@tewksbury-ma.gov for questions or comments. And then I have my phone number and my email address here. So that concludes the presentation. I did want to put up a copy, though, of the map, just in case we get into that discussion at all. But with that, I'll take questions. We should grab the microphone, too.
We all set, Steve?
Yeah, go ahead.
I'm Bruce Schick from 30 Lucille Drive. And first of all, I want to thank you for undertaking this monumental task and putting on the presentation so we can be more informed about what's going on in town. I was curious about a few things, but in particular, I was interested in why the developmental impact statement was removed, because it seems to me that's almost contrary to what you would expect would be happening these days, where people want to know more. I've been to 2 or 3 meetings where people are saying, well, what about this, what about that? And I'm thinking, it seems like that would answer a lot of questions in a very organized way.
Yeah, that's a good question. The development impact statements, what we found was that a number of those issues were already being addressed. And I want to get to the section of the bylaw so that So what the development impact statements do, describe general physical conditions to the site, amounts and varieties of vegetation, general topography. A lot of that stuff is picked up in the process when they're applying for special permits. Surface water and subsurface water conditions, locations and types of existing water and wetlands, surface drainage characteristics. All of the special permits where there's new construction development, there is a whole stormwater section and review process that goes on with DPW now. Circulation systems, as far as traffic is concerned, we put people through traffic studies, or traffic studies are provided, and then we do a peer review on those today. So a lot of these things, water distribution, sewage, refuse, fire protection, those things are all being handled in the permitting processes that exist today. So it just seemed that it was not necessary because it was already being addressed.
I'm Jack Sheehy, 2 Laurie Drive. I didn't really follow exactly on the small lot issue, the last item you covered, or I didn't get where that's going. If I understand right, it's being looked at to remove the 20% lot coverage and reduce that to 15%, but from what you just said, it sounds like that's not decided. It's still being looked at. Do I have that?
Let me get to that for you. It'll take me a minute. Okay. So here is where you see the R10 and R20 that are listed there.
Right, R40 is.
R40 is 1 acre. Instead of calling it out as 43,560 square feet, we just use 40. R20, so you can see that it has to be 1 acre for R40, half acre for R20, and a quarter acre for R10. And then we start talking about the minimum frontage, setback requirements, and then you were asking about lot coverage, and you can see that we've, didn't want to do that. For R10 and R20, we've reduced the, no, we kept that the same. Yeah, so those are the lot coverages.
On the R40 is what I'm looking at, that's my area, and that note C for
Yep.
the where you can go up to 20% down below, is that being looked at to change, or is that going to remain as is, or?
That, as it stands right now, is going to remain, but, yeah, could you write that down? Because that needs to be looked at further, now that you pointed that out. It should, that was pulled off of the existing bylaw. So I think when the committee put these two in place, we probably should have looked at this one also. So that's something that I will take back to the committee. That was a good question. Do you have any questions? No?
I'm never done.
I know you're not.
You talk about open space developments,
Mhm.
and since I have a big interest in open space in town, one of the things that I want to understand, I'm guessing it's already been addressed, but I thought I'd ask specifically, is the open space, when a development has an open space component, is that always meant to be accessible from the public street or in some way so people can get to the open space for passive use?
Not always. Not always. There have been instances where the open space remains within a homeowners association, and in those instances, it may not be accessible to the public. And what's happened is that over the course of time, the town has taken open space in a number of different subdivisions and developments, and the town ends up picking up the liability. So if you have a large open space area and it is abutting another residential neighborhood, and there's a tree that falls, it now becomes the town's responsibility to go in and crane over the top of houses in existing neighborhoods to pull these trees out of the backyard of the neighbor that it falls into. So what we're starting to see is more, the last few, 2 or 3, I think, open space residential design projects where the open space is being held in a homeowners association. So those that benefit from the reduced lot size in an open space residential design are responsible for the open space and the stormwater in some instances of these subdivisions.
So that open space would not be available for
Not-
other people
right.
to use?
Not necessarily.
Okay. Jack, do you want to have another question? Okay. Early on, you mentioned that all multifamily developments are now capped at 7 units per acre, but there were some that had exceeded that density. How many have exceeded that density, and where are they?
I think there's some along Route 38 with the new mixed-use developments that have gone in. And if I remember correctly, if I looked closely at Jones Farm and Balsam Place, it looks like they may have been about 10 units per acre. And again, those were in the Community Village Overlay District. What's being proposed is that those districts become multifamily districts. So those will be at 7 units per acre. It basically makes them pre-existing non-conforming. But the last I looked, I think that they were both at around 10 units per acre. I was anticipating that question.
I would expect you were. So just a bit of understanding, when the new bylaws go into effect, how does that transition occur if there's a change that affects a particular piece of property? Is it, if no permits have been approved under the prior zoning bylaws, the day that these things are approved is the date that you have to meet the new bylaw standards?
It's a little bit more complicated than that. It actually becomes the date of the first advertisement of the planning board's public hearing. So town meeting's May 4th. It could be that it's effective dating back to April. That's one way of looking at it. The second way of looking at it is that there are, under the State Zoning Act, the ability for people to protect their existing zoning rights through the filing of approval not required plans, which gives them a 3-year freeze on the uses at that time that the zoning change takes place. And then the State Zoning Act also allows up to an 8-year zoning freeze if the landowner submits a preliminary subdivision plan and then follows that up within 6 months with a definitive subdivision plan. So there could be grandfathering that occurs if landowners take action either on what's called an A&R plan for uses only, 3 years, or the subdivision process, which gets them up to 8 years.
Is there any assessment by your consultants as to what the impact will be if these zoning bylaws are implemented? Well, you know, on the forecast of the number of houses in town, just curious if anybody's sort of looked at, I don't even know how many houses we have today, but let's just say we have 4,000 houses, I don't know. You know, if we didn't change anything, we might have had 6 down the road. Would we have 6, 5, 7, 10 under the new zoning bylaws?
Yeah, that hasn't been done, but I can tell you that I think just by capping the multifamily developments, that in and of itself is going to help alleviate some of the pressure on housing development. You know, over the course of the last decade, there's been over 900 housing units that have been created in town. And, you know, we can look at some of them and say that those are pretty large. One at 96 and the other one at 192. But you can look at places like Chelmsford and Westford, which are seeing 300 units at a pop going up in some of their neighborhoods. So our bylaw has done well in moderating development, and I think with the new bylaw, it'll do even better in moderating development.
Okay. Oh, I had one more question
Sure.
because I used to do this kind of work in a different arena. Prompt and predictable permitting while protecting the abutters' rights. That is an absolutely laudable goal. Can you give us an estimate of what you think the difference is going to be with this set of bylaws versus the current set?
Yeah. Prompt and predictable, I'll start there. That, again, with The reorganization that we've done and the removal of the inconsistencies, a lot of times those inconsistencies become time delays and drags over interpretations. You know, well, this section of the bylaw tells me I can do this. Yeah, but we see this section of the bylaw that says you can't do that. And so we have this back and forth with applicants on occasion, which delays. So we're adding to the promptness by removing those inconsistencies and consolidating things. We're making things more predictable because you can see them in one place. And it's more predictable because it's very clear as to what is allowed by right or allowed by right with site plan review or what's required under a special permit. As far as protecting the butters' rights, you know, I think by beefing up the criteria for the issuance of special permits will be helpful to abutters. And like I said earlier, it'd also be helpful to the board, both planning board and ZBA has some special permit authority in the existing and in the proposed. But that criteria, I think, will help both boards have something that they can either say yes or no, being reflective of protecting the abutters' rights.
And here's a somewhat generic judgmental question on your part, but do you think that these bylaws are going to be more protective of, you know, people's wants and desires or less? I mean, are there any weaknesses in the new proposed bylaws? So people think, oh, this is great, we're going to fix all of our problems, which it never does. But are there any significant weaknesses in the proposed bylaws that perhaps should be looked at even further?
After 3 years of this?
I realize
No.
it was an awful question.
Yeah, no, and in all honesty, I mean, I've been here a long time, so I've been involved in operating under the existing bylaw and the amendments that we made and that we thought were achieving certain goals. And when I first got here, there was a previous bylaw to that, which had in and of itself become somewhat cumbersome. I think that on the whole, this is addressing a significant amount of issues and will put us in a better place than we are today.
I think you said there were like 120 amendments to the previous set of bylaws.
Mm-hmm.
At what point do you think we should look at redoing this set of bylaws when X number of amendments have
This one?
occurred?
Yeah, you know, how we amended over the years, back in 2002, there was a conscious decision made to recodify the bylaw, which was to give it the new numbering system and make some small modifications to it. But there were policy issues that were kind of left off the table at that point in time. And that kind of contributed to those amendments. And I think some of the amendments that were made were deleting sections that were no longer required, or, you know, Anna and I were talking this afternoon about how we shifted on our zoning districts from having them described in text to a map back in 2005. You know, so there was an amendment to the zoning bylaw, but it actually created the zoning map, which was a good thing. And then over time, a lot of those amendments were housekeeping amendments. So over time, we did housekeeping, we did policy, and I think that this draft bylaw captures a lot of the good things that we put into the existing bylaw, and I think it tweaks them and just makes them better. So what that number is of amendments in the future, I don't know. I think we'll be in a very good place if this passes.
Thank you.
All right. Thank you for attending, and again, any questions, email that that zoning at Tewksbury, email me, call me, and
You can come to the community development office.
and you can come to the community development office. So we're prepared to answer any questions you may have on it. Thank you for this evening.
Thank you again.
Thanks.
Thanks.